It's an ongoing building block into 3 different books that I'm working on. One of them is about riding with the outlaw, my adventures in being politically charged, politically framed, having all the evidence of government involvement, deep state involvement, a bunch of corrupt attorneys, even the courts. The second one's going to be about all the shenanigans with Phyllis Liz Crowder, my ex, mother of my child. The false, just insanity that encompasses that. All the frivolous, false claims, and my stand against it. Even when it came to having to represent myself, because I couldn't find an attorney to help me. Meanwhile, she's got attorneys bending over backwards to help defend her lies. I'm pretty sure we're on a third. And that'll be the more familial aspect. About how my family turned it back on me. Especially at a time that I needed them the most. Especially in seeing the undeniable proof. Seeing me steadily drowning more and more, sinking in quicksand, and yet it's one thing not to contribute about. It's another thing to actually completely turn your back on somebody that is struggling with the particular things that I've run into. With all the adversity, the biggest challenges of my life, having to be one man going up against a ridiculously corrupt system that continues to break laws, that continues to carry their witch hunt on. I need a prayer.
The whole legal system has gone completely perverted. I don't know about other cases, I don't know about other people outside of what I'm particularly dealing in. But I've made numerous references to this over the past year and a half. Honestly, the last 4 years. It always used to be presumption of innocence until proven guilty in a court of law, backed by the Constitution. And I guess the Chancery Court of Lafayette County, Judge Robert Whitwell, that doesn't apply to. At least for me, it's a presumption of guilt until 100% of your innocence is proven. And with that comes taking away the right to even see my daughter over and over again. The evidence proves that this court in particular has been the biggest pivoting turning point for Lafayette County. And now I realize this is truly where my fight is. It's child exploitation. It's child trafficking through the Chancery Court of Lafayette County.
Petition for permission to interlocutory appeal to the Mississippi Supreme Court. Pursuant to Rule 5 of the Mississippi Rules of Appellate Procedure, Matthew Reardon, the respondent and defendant in the above captioned cause, files his petition for permission to interlocutory appeal to the Mississippi Supreme Court. Movant states that this petition is filed in good timing and most certainly with good merit, based on grounds for which relief through interlocutory appeal may be sought. Movant would affirm that he has continued to sustain repetitive injuries at the baseless, frivolous, and vindictive hands of the petitioner, the petitioner's legal counsel, along with the state of Mississippi. Movant states that each motion brought before this court has been prejudicially ignored, with preferential treatment shown to the petitioner in this cause the entire time, despite the fact that petitioner has had a history of filing false reports, and this very cause will show the furtherance of petitioner's continued behavior, which is not only morally incomprehensible, but in fact rises to the level of criminal conduct by flagrant and uncaring violations of Mississippi Code 97-7-10, fraudulent statements and representations, along with Mississippi Code 97-1-1, conspiracy, which the state of Mississippi has refused to acknowledge, condemn, and deter, despite petitioner meeting literally every criteria of the statute needed for indictment by a grand jury. Yet through what would easily appear to be culpable negligence at the hands of state actors acting under color of law, she has continued to get away with the intentional infliction of injuries upon the respondent/movant, and this court is further feeding into it by immorally changing a standing order when absolutely no evidence was produced and court proceedings were delayed. Movant further demonstrates the preferential treatment shown through his filing of a motion to dismiss, or in the alternative to transfer venue, filed 11/16/2020, on the basis that venue, while jurisdictionally is proper, is in fact improper in the Chancery Court of Lafayette County, Mississippi, due to reasons of constitutional law, equity sought and counterclaimed by the respondent due to the injuries sustained, zero evidence produced up front as a way of justifying 9 months contempt in violating a visitation order, and a jury demand by the respondent and movant for these reasons stated. This motion is attached to this filing as Exhibit A. It would most certainly appear that any response or forward motion brought by movant is destined to fall on blind eyes and deaf ears, despite all evidence almost certainly warranting the dismissal of petitioner's cause. Petitioner, along with this court, moved on their own to enter an order of supervised visitation and appointment of guardian ad litem, which was drafted by the petitioner's attorney, accepted, signed by the judge, and filed by this court unsigned by the movant, despite his motion to dismiss or transfer being open, unanswered, and ignored by this court. Order filed to judge without movant's signature is attached as Exhibit B. Despite serious issues of law, ethics, and criminal wrongdoing raised and alleged, none of this mattered. It is entirely the opinion of the movant that influence, along with ongoing pending litigation over extreme civil rights violations committed through officials of Lafayette County, have in turn created what movant cites as a constitutional crisis by way of trying to fix a desirable outcome through the initiation of frivolous and undeserving proceedings done with ill intention, and further using the pressure of keeping movant's minor child from him to make him cave on a matter. This was precisely the case in May of 2017, and movant has been consistent in stating the same claims about how his minor child was used as a manipulation tool of the courts by the minor child's mother for her own personal gain, whom by ways of collusion and criminal conspiracy plotted in many ways were successful in eliminating or reducing the legal liability stemming from the actions of certain individuals and officials in Lafayette County, Mississippi, whom will be named in a separate court filing. The fact that this court allows her to carry on despite her claims raised as complete lies, and in light of her having a history of pathological lying through the false reporting of crimes, is an absolute shame, and one that should question the validity of other rulings, or if this was simply isolated. While movant has continued to gain more legal knowledge, especially in the composing of briefs, motions, petitions, and responses, true justice is nowhere in sight. Movant asserts and affirms through multiple recent examples, including this cause, there's been a clearly shown lack of adherence and care to the equal protections under the laws which are afforded to all citizens under the 14th Amendment to the United States Constitution, a system designed to provide due process, and one that should stay non-biased, would appear to have drifted away from acceptable norms that would garner and keep the trust of citizens. It is now clouded with uncertainty The first question Movant would pose is what good are laws and why were laws instituted if they could be so bludgeoned and blatantly abused? Even when such abuse is brought to the attention of those tasked with upholding and enforcing the laws, does the state of Mississippi actually condone this type of behavior? And even more so, do they condone the culpably negligent actors, whom are fully aware of it, and allow the continuation of such, despite the damage continuously inflicted by the victim, who has exhausted all remedies and seeking immediate relief from the government tasked with protecting its citizens by way of providing equal protections under the laws. Our country is operated under the policy in name of innocent until proven guilty in a court of law. I say in name because it's something that exists clearly just to sound good and give off false hope to anyone suffering at the hands of a completely flawed criminal justice system, when in fact all too often the accused is looked at and treated as guilty until they prove their innocence. That fact is made blatantly clear in this cause, and it couldn't be any clearer. After 2 scheduled hearings, the petitioner has not produced one single strand of evidence which would even suggest she has a valid, non-frivolous claim. And in fact, every motion and response filed by respondent Movant has stated in fact very serious claims of petitioner having a history of making false reports, and that Movant was advised multiple times that the petitioner was lying through her teeth, and that they would never assert any of the such, which petitioner has asserted now on 3 separately filed documents filed with this court under signed and sworn affidavit. Has this court even one time considered an obvious, most certain guarantee that law enforcement would have been involved had any of petitioner's claims been true? There would have been some report by the proper agency and authorities brought before this court shown up front as grounds to keep a father from normal scheduled visitation with his child for 10 months now. Even more concerning is the fact that Movant was barred from even seeing his child by the petitioner in this cause, despite her being in receipt of $600 in child support paid every month.
Hey, it's Matt Reardon, the Oxford Outlaw. Wanted to bring you some news. Today I filed a writ of mandamus in circuit court at the circuit clerk's office against Circuit Court Judge John Kelly Luther and Justice Court Judge Carolyn Bell. All signs pointed to Judge John Kelly Luther playing a crucial part in everything back to 2017. In fact, there have been numerous examples. The attorney in my case that represented me, that came on and represented me, Brennan Horan, who actually made direct reference to John Kelly Luther being somebody that he quill hunted with. Ray Tannehill being somebody that he was in law school with. And John Kelly Luther has adamantly refused to entertain the actual facts that happened in that cause, the laws that were broken by state actors, the rules that were ignored, that were purposefully ignored by government employees, by the sheriff's department, by the courts. The due process rights, constitutional rights that I was downright refused. And the intentional incarceration and jailing of me for 6 weeks' time, refusing to entertain a bond reduction hearing, refusing to lower the bond to a constitutionally fit amount, instead choosing to leave it at a constitutionally unsound amount of $150,000, which was 3 times higher than the maximum, the guidelines established in the Mississippi Rules for Criminal Procedure that was republished earlier that year. for the crime that I was charged, which was aggravated stalking, which then changed to cyber stalking. Aggravated stalking is a crime that sees a maximum 5 years incarceration if found guilty. Any crime with a maximum incarceration of up to 10 years. The guidelines established by the Mississippi Supreme Court finally detail that the range should be between $5,000 and $50,000. Judge Carolyn Bell, who knew better, who definitely, without a doubt, knew better. Because, I mean, after all, this is the judge that has had a habit of setting bonds on the lower end of the guideline scale. I mean, she set a accused rapist and kidnapper, set his bond at $20,000, gave him a $10,000 bond on each of the two criminal charges, very serious criminal charges. $10,000 for rape, $10,000 for kidnapping. But a Marine Corps veteran, a patriot, somebody that never actually caused any harm on anybody and didn't actually issue any kind of threats of physical harm. It was all political since day one, and it was part of a plan to silence me, to keep the incoming socialist mayor's biggest adversary at bay, to use criminal prosecution and incarceration as a way of suppressing somebody that didn't align politically, and having enough power and sway in order to move the courts and get the cooperation of the sheriff's department, of the judges, of certain key government officials in the area, in order to successfully pull off what would become a just ridiculous quid pro quo plot that up until now they've been successful. And boy, is it employed the help of many. And what I'm here to do is to bring the truth to the light, to show how this is spiderwebbed out of control, and to show that the people in these positions of power within the government have been destroying lives. And they've been destroying lives on taxpayer dollars. And what this has become is it's become a treason just nightmare. It's got treason written all over it. I said since the beginning it needed to be prosecuted under the RICO Act, and it certainly does. And why the hell the FBI and Department of Justice has refused to even look into it is downright appalling. I've got four different calls with the Mississippi Bureau of Investigations, the MBI. It's the state version of the FBI for Mississippi. And after I had realized that the FBI, the U.S. Attorney's Office, which in turn would directly implicate the Department of Justice, was complicit in all of this by way of destroying records, exfoliation of evidence, and fraudulent concealment. I've gone to the MBI. I've reached out to them, simply asking for a full, fair, and impartial investigation to be conducted. Serious allegations at play, serious allegations that have been backed up by fact. Each time I'm told that somebody with the MBI is going to reach out to me, that I'll hear from somebody within their ranks. I've asked for Colonel Morrison, Lieutenant Colonel Morrison, on each of the 4 times. haven't spoken with the Lieutenant Colonel Morrison, who's the commander. Okay? And I'm looking to hold somebody accountable, whoever, or multiple. Because these people are paid to do a job to protect us. And when serious allegations are made, serious crimes are occurring, which are ultimately just, they're destroying lives. And it's happening on a regular basis, and it's happening on taxpayer dollars. Riding with the outlaw is about accountability. It's about responsibility. It's not about fame. And you can see it's not about fortune. In fact, this has been something that I've dedicated myself to because it's that serious of an ordeal to me. I've put my life on the line in order for my kids, not only myself, to have an opportunity at a future, but my kids. Also America, because as I've said since day one, being a Marine Corps veteran, I wrote a blank check to our country for an amount up to my life. I swore an oath that never expires, even though I'm out. And I swore that to our government. And if our government can turn the gun around on one of its own that made that kind of pledge, a lifelong pledge to uphold and defend its Constitution and to protect it from all enemies, foreign and domestic, if they can do that to a Marine Corps veteran, you bet your ass they could do it to any single person next. Precedence is what has run this country all along. It's run the courts, it's run law enforcement, it's run politics. Hold your people accountable. In the Circuit Court of Lafayette County, Mississippi, Matthew Reardon, plaintiff, versus Judge John Kelly Luther and Judge Carolyn Bell, defendant. This is the petition for writ of mandamus. Plaintiff Matthew Reardon hereby petitions for a writ of mandamus and seeks an order from the higher court granting this petition for a writ of mandamus and directing the circuit court judge to grant relief sought on his motion filed December 23, 2020, in conjunction with criminal cause LK17-295, or in the alternative to promptly recuse himself as trial judge. Plaintiff in this cause has faced some of the most extreme prejudicial treatment and handling by the state of Mississippi, whom plaintiff directly asserts has continued to persecute the plaintiff on a plethora of criminal charges in order to attempt to stack the deck and demonize him in the eyes of the public, along with various courts. Plaintiff stands exhausted and mentally fatigued from having to prepare defense to an ever-growing list of court hearings, all of which directly stem from the original ruling made July 7, 2017 in criminal cause LK17-295, in which Judge John Kelly Luther presided and ruled in what plaintiff asserts to be the most tainted, corrupt, highly prejudicial, and unlawful legal charade, which is a complete abuse of power and proceeding, aka witch hunt, in at least the last decade, if not the past century. Plaintiff has continued and will continue asserting his claim that the trial court knowingly chose to toss its own procedures, rules, laws, ethics, and moral turpitude to the wayside, and in the act of doing so blatantly disregarded mandated procedures laid out in the Mississippi Rules of Criminal Procedure, which was detailed out in the plaintiff's motion for relief from judgment under MRCP Rule 60 submitted to the trial court on December 23, 2020. Plaintiff acknowledges that he has a pending appeal before the Court of Appeals, which was recently docketed on 3/10/2021. However, MRCP Rule 60 states, to wit, leave to make the motion need not be attained from the appellate court unless the record has been transmitted to the appellate court and the action remains pending therein. Plaintiff is beyond belief that the defendant circuit court judge has not only been allowed to continue proceeding over this case, but other cases amongst the serious claims made, which he adamantly has refused the plaintiff an opportunity for an evidentiary hearing which the record itself and the facts of the criminal cause LK17-295 should not even require, based upon interpretation of the Mississippi Rules of Criminal Procedure, the Mississippi Rules of Civil Procedure, and the Code of Judicial Performance. It is the impression of the plaintiff that there is only one acceptable remedy to this matter: to vacate the plea and judgment entirely, based solely in principle on the state of Mississippi and both defendant judges denying the plaintiff on this writ certain key due process unalienable rights, and in turn denying him all opportunities for a fair trial to take place. As stated all along, and particularly in the motion submitted on December 23, 2020, the meritorious reasons that have been claimed and listed should in fact render the plea and judgment to be null and void, even unlawful and unconstitutional, based upon established state and federal law and longstanding court precedents based upon the seriousness of everything. These incurable errors have been previously detailed out, but include, among others, fraud, misrepresentation, misconduct of an adverse party, newly discovered evidence, the fact that petitioner's bond was set unconstitutionally high in a punitive way, 3 times higher than the maximum stated on the guidelines for bail, readopted less than a year prior, a habeas corpus petition approved by Judge Howarth, which was never acted upon, no preliminary hearing ever being set, and all bond reduction requests completely ignored. At this point, plaintiff would naturally have to question the misconduct at hand, further characterizing it as intentional criminal conduct, which would give off all feelings and impressions of a deeper level of involvement from the grave misconduct of the 2 judicial officials listed in this petition, along with Municipal Court Judge Leslie Shoemake, which is currently pending before the U.S. District Court of the Northern District. Plaintiff formally requests for an impartial formal investigation to be ordered into the claims plaintiff has made and produced evidence of, and for the plea and judgment on LK17-295 to be rendered invalid, or in the alternative, for a hearing on the evidence and facts to be ordered. Should a hearing on the evidence and facts be ordered, plaintiff immediately moves for recusal of Circuit Court Judge John Kelly Luther from the matter due to the grievances listed, along with the inability to preside following submission of a writ of mandamus, which requires further that the Circuit Court Judge recuse himself from all matters involving the plaintiff. Plaintiff requests for the Justice Court Judge Carolyn Bell to be remanded for her actions in setting an unconstitutional bond 3 times higher than the maximum guidelines called for in LK17-295, and further refusing to allow the defendant in that cause to speak in order to show unquestionable proof of his innocence to the matter, nor allowing the defendant in the cause to proceed with setting a preliminary hearing. Filed motion for relief from judgment under MRCP Rule 60 is filed and attached hereto as Exhibit A. Respectfully submitted. The first day of April 2021. This is not an April Fool's Day joke. Matt Reardon, the Oxford Outlaw.